I'm waiting for the slides. All right. Our title was the justiciability of the right to development and peace within the context of elections, and it was a case study of the role of the judiciary of Kenya. The main saying that guides this paper is, without peace, there can be no development, and without development, there cannot be peace. This is a saying that has been said by several people. I do not even know who to attribute it to, so I attributed it to the person who is from the UN. And what essentially this saying means is that these sustainable development goals that are here, the 17 of them, they can't be attained if there's no peace, and vice versa. If there is no development, there won't be peace. And this also leads us to know what is sustainable development. The United Nations comes up with a definition of development as a need, as the development that meets the needs of the present without compromising the ability of future generations to meet their own needs. And development in this instance is the comprehensive economic, social, cultural, and political process which aims at the constant improvement of the well-being of the entire population and of all individuals on the basis of their active, free, and meaningful participation in development and in the fair distribution of benefits resulting therefrom. This definition is derived from the declaration, is categorized as a third generation right, and this categorization of human rights came from Karel Vasak in 1977 in his paper. He categorized the human rights into 3 generations. The first generation rights are the civil and political rights, such as the right to life, freedom of speech, freedom of religion, the right to fair trial, equality before the law, whilst the second generation rights are economic, social, and cultural rights, such as the right to work, and the right to education, the right to health, whilst the third generation rights, which is what is the focus of this paper, includes the right to development, to peace, and to a healthy environment. And the next slide on, I don't know, there's a generation that did this book as a set book, Animal Farm by George Orwell. And this is a very famous saying from that book that all animals are equal, but some animals are more equal than others. This is very applicable in this categorization of rights. It's a principle of human rights that all human rights are equal. Yet, we still categorize them and give priority to other rights. For instance, the civil and political rights are prioritized as the first priority. And the socio-economic rights under Article 43 of the Constitution are actually told they should be progressively realized. And now the third generation rights are the worst. Some do not even see them as justiciable rights, and because of that, there is little jurisprudence in Kenya, especially on the right to development and to peace. At least the right to a healthy environment has been litigated on, but the right to development is still an emerging jurisprudence in Kenya. And this right to development is not even specifically provided for under our constitution, although it's recognized, sustainable development is recognized as a principle of of governance and a national value for governance under Article 10 of the Constitution, but it's not expressly provided for. And interestingly, the only instrument or law that specifically provides for the right of development as a justiciable right is the African Charter on Human and People's Rights. It's provided for under Article 22 of the African Charter, which provides that all people shall have the right to their economic, social, and cultural development with due regard to their freedom and identity, and in the equal enjoyment of the common heritage of mankind. Not many instruments or laws specifically expressly, they just imply it in their laws. For instance, and also the Declaration of the Right to Development, which is just a declaration, which also provides that the right to development is an inalienable human right by virtue of which every human person and all people are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development in which all human rights and fundamental freedoms can be realized. Interestingly, the African Commission was the first. The African Commission was the first institution to recognize the right to development as a justiciable right. In the case of the Nderois case, in this case, the Nderois community were being evicted from their land by the government so that the government could set up a game reserve. They approached the African Commission with the view of saying that their right to development had been violated, and the African Commission was of the view that the state bears the burden for creating conditions favorable for people's development. With regard to seeing the rights that are there, there's a need to go into how the judiciary has their role in promoting peace and development. As I've said, there is not much on the right to development, but on peace, there's a lot of jurisprudence in the context of elections. And so we can begin with a background in the history of Kenya. Our legal system, we adopted it from the British legal system when Kenya became a protectorate in 1895. And that's where we can trace the roots of our court. And at that point, pre-independence in 1963, the judiciary was a tool of imperialism. And a case in point is the Kapenguria 6 trial in 1952 after a state of emergency was declared. In this instant, it's a very sad situation because the presiding judge, Ransley Thacker, he had retired. He had served in the judiciary from around 1933 to 1950. He retired. He was given his pension of £474, and he went home. Then in 1952, Governor Sir Evelyn Baring called